Welcome back to the UPC Insights, your trusted podcast for the latest updates and analysis on patent law and the Unified Patent Court. I'm your host, George Walden, and today we return to the topic that's generating a lot of discussion in the legal community: preliminary injunctions before the UPC. In today's episode, we're looking into a major decision from the Unified Patent Court's Court of Appeal regarding such provisional measures. This case, the UPC COA 382-2024, involves Abbott Diabetes Care Incorporated and a Chinese-Dutch company, Symbionix, in a high-stakes dispute over a contentious glucose monitoring, the CGM technology. Joining me once again is our man, Tillman Frank, a distinguished expert on UPC case law and patent litigation strategy. But before we dive in, I wanted to take a moment to recognize Tillman for something quite special. Tillman, congratulations on being nominated for Patent Practitioner of the Year by Managing IP. That's an incredible achievement and a testament to your outstanding contributions to the field, and I'm proud to be able to work with you.
Thank you very much, George. Thank you. Yeah, well, that's truly an honor, I must say, to be recognized in such a way. Even better, by the way, Meissner Bolte is nominated as Firm of the Year for Patent Prosecution. Yeah, which makes us, of course, extremely happy. Yeah, well, the nomination itself is a great recognition of our work so far, particularly in relation to the evolving case law under the UPC framework. I'm really grateful to the hard work of all of the colleagues at Meissner Bolte and all the clients who've supported and trusted us along the way. I mean, without clients, we would be nothing, that's for sure.
That's for sure. That's for sure. But it's a great honor, and it's fantastic to hear, Tillman. And I'm sure our listeners will be following the results closely. And I'll be figuring out how I can stuff the ballot box for you to make sure that you win, and then become your Oscar and your moment in the sunshine with the rest of us. So now let's get started and get the results there. But once again, Tillman, congratulations. So here's my first question. Tillman, you reviewed the decision I mentioned in detail. What makes this ruling particularly significant for patent holders and defendants alike?
Yeah, George, that case is important for plurality of reasons, I would even say. I mean, it's about preliminary injunction. This is always interesting. Anyway, from a German perspective, the idea of the requirement that infringement must be more likely than not, and that validity must be more likely than not, is still extreme.
Okay.
But this is now settled case law in front of the Court of Appeal, and we do not have to talk about in much detail anymore. But there are some new, or not so new, but under the jurisdiction of the UPC, new aspects and ideas. First, relating to the claim interpretation and the so-called means plus function language. In that regard, the court confirmed that functional claim language must be interpreted broadly, meaning that any structure capable of performing the function is covered.
Okay.
The second, relating directly to preliminary injunctions, or injunctions maybe also in general, we have to see that. They found that a general injunction can be granted based on just one type of likely infringement, even if there are multiple ways an infringer could operate. Then the third headnote clarifies an important procedural point under the Unified Patent Court Agreement, the UPC-A, namely that measures under Article 67 of the UPC agreement, such as orders to provide information or seize infringing goods, can be granted within provisional measure proceedings, not just in final decisions on the merits. And last, interesting, at least for me, also, it's not, you will not find in the headnote, but in the grounds of the decision about the urgency in UPC proceedings. There's always an urgency requirement. This is settled also in front of the Court of Appeal. However, in my opinion, this decision suggests that the UPC may take a rather relaxed approach to urgency, which could have major implications for future injunction requests, I guess.
So that is a lot to unpack, my friend. So let's start with the claim interpretation issue. What did the court say about interpreting means plus function claims?
Yeah, good question. In the present case, it was about a specific feature, so-called feature 122 in the analysis of the court, requiring a base portion configured to be adhered to the skin surface of the subject by an adhesive patch.
Okay.
This is a rather standard terminology in a patent claim, I would say. And in this case, the Court of Appeal agreed with the claimant in saying that the words configure to must be understood to mean suitable for.
Mm-hmm.
As already said in my summary of the decision, this is not totally new. It's more a general principle of interpretation.
Mm-hmm.
So that means plus function features must be understood as any features suitable for carrying out the function. You will find similar ideas also in the guidelines of the EPO and in national case law. This is, as said, not a new concept, but now the first time that the Court of Appeal clarifies it from their perspective.
Okay. So this decision reinforces the broad interpretation of functional claim language, which should be good news for patent owners, right?
Yeah. Normally, yes.
Normally, yes. Here we go. Okay.
Normally, yes. I mean, sure, from a patent owner's perspective, it's always good to have a claim which is as broad as possible. And
Mm-hmm.
the more broader you interpret it, the more broader the scope of protection is, of course. Therefore, it's good. It's good news. However, sometimes also you are on the defending side, even as a patent owner. Normally, if the potential infringer or any other person files a revocation action or something like that, opposition at the EPO, and then very often you have a high interest also to argue for a narrow scope of protection. But also in that situation, of course, you are bound by this interpretative rule. So also in that situation, you must accept that the claim is maybe broader as you wish in your when you are defending the patent. I have to add that you could again counter-argue, well, in defending the patent, it's not that difficult. You just restrict your claim by an auxiliary request or by any limitation. But that is theoretically, this would be the solution. But in practice, it's in many cases very difficult in front of the EPO and also in front of the UPC to find a proper wording in the original disclosure so that you can actually do that.
So you're saying after you receive a judgment and maybe in your favor, the opposition could still try to find a way to reverse it? Is that what I'm understanding?
Yeah, well, I mean, there in that case, there may be one or two different scenarios. Let's assume there was a final judgment on infringement, yes, and it might well be that, for example, the European Patent Office in a still pending opposition proceedings revokes the patent thereafter, and maybe exactly because they adapt the broad interpretation of the UPC. At least this is how it should be. And then you see the negative, potential negative impact for the patent owner.
Okay. It seems a little bit unclear if you win and then you don't really win. But maybe I'm getting ahead of myself, So, well, let me put it this way. Now, what about the second key takeaway, the general injunction? I understand the court took a rather expansive approach.
Yeah, you can say that exactly. The Court of Appeal made it clear that a general injunction can be issued even if the patent holder only proves one likely infringement act. Okay. So in that specific case, Apple sought to block Sibionics from making, offering, selling, importing, or storing the infringing CGM devices. And Sibionics argued, of course, I would say, that Abbott had not proven infringement for all those possible infringing acts. But the Court of Appeal rejected this argument, saying that proving one likely type of infringement, in this case, I think it was Sibionics offering the infringing device for sale, was sufficient to justify an injunction covering all possible infringement scenarios. So, for example, also the selling, the making, and so on.
Okay.
So this means the defendant, in that case, and general defendants can now no longer escape a general injunction just because they might have performed only one specific act of infringement.
Okay, it's starting to become a little bit clear. So then that's a strong stance from the UPC. It could make it easier for patent holders to secure broad injunctions without having to prove every theoretical way an infringer could operate. So, but now let's talk about the urgency requirement. Traditionally, courts expect plaintiffs to act swiftly when seeking preliminary measures. Did Abbott face any pushback for taking a few months before filing its request?
Yes.
Okay.
Um, but the court ultimately ruled in Abbott's favor. Sibionics, the defendant, argued that Abbott's request lacked urgency because Abbott had seen Sibionics' device at trade fairs months before filing its injunction request. I think it was even 4 or 5 months.
Okay.
And they, by the way, they also argued that they could have sold, and they did purchase one product in December or so, December 2024. However, Abbott took more time and counter-argued that they needed this time to obtain samples from the Sibionics online store. Okay, they did this in December, I said, and then conduct a detailed X-ray analysis of the internal components. And then also they argued that they had to coordinate multiple parallel infringement actions across different jurisdictions. But in the end, it was between the purchase of the product and the filing of the application for preliminary injunction, almost 3 months or even a little bit more. And even between the, let's say, the result of the X-ray analysis and the application for preliminary injunction, more than 1 month has lapsed. And this is normally, in the German tradition at least, so kind of an unofficial deadline. So 1 month from the time where you can be rather certain about the infringement. And in that case, it was even that the Court of Appeal acknowledged that the X-ray analysis was, at least with hindsight, and this was maybe the critical point, with hindsight not necessary to find infringement. But they say, well, with hindsight, you can say a lot, and therefore they accepted that it's okay for the claimant to bulletproof or try to make the case watertight in that respect.
Right. So, but it wouldn't be considered a stalling technique.
No, I think if they would have seen something like that, then they would not have allowed the preliminary injunction because of lack of urgency. Yeah. But they, in the end, I think at least from a German perspective, again, in my opinion, rather liberal. I mean, they accepted 3 months between purchase and then filing the request, and they accepted a little bit more than 1 month between having the result of this X-ray analysis and filing the request and so on. It's more liberal than we are used to in Germany.
No, that's a pretty big deal, my friend. It gives patent owners more time to gather solid evidence before rushing into an injunction request, I guess. But before we wrap it up, what are the broader implications of this decision for patent litigation in the UPC?
Yeah, to wrap it up, I mean, I would say this ruling, again, strengthens the position of patent holders in several ways. We learned about a rather broad claim interpretation, meaning that infringers will continue to struggle to escape liability by tweaking product designs. Then this is a huge benefit for any patent owner. And general injunctions are possible. And now it's much easier to stop infringers comprehensively rather than having to fight over specific acts. And as said, I mean, you can dispute this maybe, but in my opinion, we have seen a rather relaxed urgency requirement, allowing patent owners to take the time to build a strong case before seeking preliminary measures. Maybe for defendants, this decision is another wake-up call.
Yeah, I could say that. Yeah, definitely.
They cannot rely on narrow interpretations of functional claim language. Like in China, for example. I mean, in China, it would be much different as far as I understand. In Europe, in front of the UPC, defendants cannot argue that an injunction should be limited to specific infringement acts. And potential defendants need to be ready to act fast if an injunction is filed, because the UPC is not demanding extreme urgency from patent holders. So yeah, well, that would be my summary.
So yeah, I mean, it's an excellent summary. My point would be, is it you would think that if you're the patent holder, that people trying to infringe upon the rights or trying to tweak it some way to use it, it's like, are the infringers, have they gotten more bold in their approach towards, and do the patent holders, or is it a patent holders world where the patent holder still has the majority of the power against infringement rights?
I mean, normally and in general, the patent owner is in a more difficult situation. I mean, you must never forget the patent owner has to win two cases, actually. The infringement case as such and the revocation case, which in at least every high-stake case and maybe 90% of all cases is raised. If the owner loses one of those cases, he loses the case overall.
Oof.
So
Okay.
still, the patent
sunshine
owner is
at
not
the end of the tunnel.
have sunshine for all the infringers out there.
Yeah.
But you see again that the UPC is a court which is willing to defend the existing rights of the patent owners.
Okay. But that's pretty interesting, because it just seems like everything is so open these days. But that's a brilliant summary, Tillman, and the decision could really shape how companies approach preliminary injunctions in the UPC. And before we go, congratulations again on your nomination for the Patent Practitioner of the Year by Managing IP. Well deserved, my friend. Well deserved, and I hope you win it. When will we find out? When is the award
10th
day?
of April in London, actually.
10th of April.
I hope I can be there because I have an oral proceedings on that
day. Well, if you don't show up to the oral proceedings, let's just say there will be signs, champagne bottles popping, and everything else. So who knows? Okay. To our listeners, if you found this episode insightful, don't forget to subscribe and leave a review, and stay tuned for our next deep dive into another key UPC ruling. Until next time, I'm George Walden with Tillman Frank. See you soon, and Tillman, good luck once again.
Thank you. Auf Wiedersehen.
Auf Wiedersehen.